Welcome to this masterclass for founders of African startups. Our topic today is planning for cross-territory IP protection for startups anticipating to expand into various African countries. And we have in the room with us Àjèbó from the Tony Àjèbó Foundation. My name is Christoph Oosthuizen. It's a bit of a long surname, so I abbreviated it there on the name tag. I'm from the Àjèbó Foundation, and together the Àjèbó and Tony Àjèbó Foundation offers this as a service to founders who are expanding in the space of startups, where they are building their businesses and where they need to plan for the future, not only where they're operating right now, but which countries or territories they will be going into. And our focus today is on understanding how to plan for protecting your IP as you are on that journey. So welcome. We've got in the room about 20, just over 20 people by now. So Aristide, Chaka, Femi, Joanna, Kabu, Marvin, Majid. Welcome, guys. There will be a few more joining. We had a good number of people that signed up for this masterclass, and we should see a few more coming in just now. As normal, it takes a moment or two, especially if you're the first time on a platform like this. So, by the way, if you haven't used Zoom, which is the platform that we're using before, on the bottom of your screen, you will see that there is a bar with some icons on, and you can open the chat bar now and perhaps introduce yourself to say where you're from and what your business is about, what your startup is about, if you're in a startup, or what your relationship with the startup is, if you're not in a startup yourself. So just click that speech bubble that says chat, and a window will open. We can ask the panelists also to just say hi there, so everyone can get used to it. We encourage you to actually participate in discussion there. So if someone says something during our masterclass and it's noteworthy for you, you can put a comment there, you can participate in the discussion. So by the way, this is also the opportunity for you to build your network and connect with other entrepreneurs from different African countries, and for them to get know what you're about. So make use of that text chat in that regard. I don't see much activity there, so but we'll as we go along in the masterclass get used to it, I hope. If you have a question though, don't put it in the text chat because it's going to get lost there. There's another button that you must click which says Q&A, and if you click the Q&A button, you'll be able to post a question there for us to address. Okay, so but that's enough about the arrangements about how we organize ourselves. I want to ask Àjèbó. She unfortunately has to run off. She's standing in for Alexandria, who's the normal Tony Àjèbó Foundation representative here on the masterclass. But Àjèbó, if you can briefly introduce to those of us that may not know the Tony Àjèbó Foundation and what you do. And we do understand that there's something that you have to run off to soon. So we'll excuse you by then.
Hi, everyone. My name is Àjèbó, and I work at the Tony Àjèbó Foundation. So at the moment, I handle branding for the foundation. So I'm working dually as the brand executive of the foundation, as well as the executive assistant to the CEO of the foundation. So that basically summarizes the scope of my responsibilities at the moment. And I'm standing in for Alex, so feel free to ask any questions. Thank you.
Maybe if you can, the Tony Àjèbó Foundation has got an alumni program where you are engaging on an ongoing basis with people that's been part of your programs. I know that because that's what Alex's main job is. But annually, you've got a program where you reach out to new entrepreneurs too. Maybe you can just tell us a bit about that.
Okay, so as some of you might know, the Tony Àjèbó Foundation is the largest philanthropy in Africa, and we're dedicated to identifying, mentoring, sponsoring, and training entrepreneurs across all 54 African states. So the only criteria for applying is have a business idea, and if you already have a business, it has to be under 3 years old. So The application drive will be opening on the 1st of January all the way through to the end of March. And we encourage everyone, regardless of what country you're from, what type of business you have. Our program is actually sector agnostic. So we don't focus on just businesses in tech or businesses in healthcare. You can be in fashion, you can be in retail. There's no limits. As long as you have a business idea and you're very passionate about what you do, and you meet the application deadline pretty much, then you're welcome to apply. We also have a very, very dedicated program management team. So we take questions all the time. So if you're not sure about certain aspects of your application, feel free to send an email and someone will always respond regardless of the timeline.
Great stuff. That is very briefly about the Tony Lemire Foundation. You may wonder also what the HWIP Foundation is about. Well, in fact, the HWIP Foundation functions alongside the HWIP Fund, which is an early stage venture capital fund that invests in startups. The foundation operates more in the capacity building side, in supporting entrepreneurs and also working with other entrepreneurial ecosystem players that are supporting entrepreneurs to make sure that those startups can grow, that we give them the best chance, if I can put it that way. So if you are interested to connect with HWIP, you can go to the hwip.org or the hwip.com if it's about the fund, and you can let us know there what your interest is in connecting with us. So thank you very much. It will be, so if you need to run, you can stay as long as you wish, but if you need to run, we'll understand that you have that other commitment that you've had prior to us meeting you today. So let's get thank you very much. And then also just give our condolences to Alex for the bereavement, please. But let's get into the topic of today. I'm going to start off by launching a poll, which we all can participate in, and it should pop up on your screen now. The poll question is basically, let's see if I can fit it in there. Sorry, I didn't get my dimensions right, but that should do for now. The question is, have you taken steps to protect your trademarks already? And you can have a choice there. No, I do not have much to do with trademarks, or no, I have not taken no steps yet, but may do so soon. Yes, I've spoken to an attorney. Yes, I've conducted an available search. Yes, I filed a trademark application in one jurisdiction already. Or yes, I filed the trademark application in more than one jurisdiction. Or lastly, none of the above. And if there's something that you want to comment about, you can do so in the text chat. So that window would have popped up in front of you, and we've got the poll running there. So let's see how that works out for us. Lots of voting happening. It looks like no, I have taken no steps yet, but may do so soon is fast getting to the top of the list. So if you want to vote, do so quickly, because I'm going to end the poll soon so that we have a result. So I'll give you another second to vote there. Okay, I've ended the poll. And basically, what we see is that 3/4 of the people, I'll share the results with you guys. 3/4 of the people on the webinar in this masterclass are saying, no, I've taken no steps yet, but may do so soon. So you're in the right place, by the way, because we're going to talk about planning for the future. And then some say they're not really so interested in it. And some have done availability searches. So all of us are really early on in the journey of dealing with IP protection and trademarks. So Neil, that's a good question, good substance for us to work about, because we know that everyone in the room is looking to learn quite a bit. So we do have in the room 2 trademark and IP experts. Let me put the gallery view on, and we can see everyone in the room. So we've got Neale Christy from Adams & Adams. He's specifically working in the trademark division of Adams & Adams, and offering services to a range of businesses and advising them in cross-border transaction types and as well, apart from the trademark registration processes, and supporting them in that process, not only in Cape Town, he's based in the same town as I am, but across the continent, Nigeria, Ghana, Uganda, Kenya. So welcome, Neale. We're looking forward to learn from you today. And then we also have Kema Ufelle-Smith in the room, who is from Capitalfield Attorneys, and is also the founder of a startup that offers a legal service. We can maybe hear more about that too, Kema, as we go along in the masterclass. But yeah, sort of offering legal services and engaging with entrepreneurs and startups directly in their needs for protecting themselves as they go into different territories. Great, so that's a quick introduction. Maybe we can come to you, Neale, first. If you can, let me see, maybe I can unmute you, then you don't have to struggle there. I'll unmute you. Oops, I think we both, oh, there you are. Now we both, oh, there you are. So you should be able to speak now. Great, what did I leave out in terms of introduction to you?
I think you covered it perfectly. Thanks, Christoph. And yeah, welcome to all of the attendees, as well as my fellow panelists. It's a great privilege to be here, speaking about IP protection, not just in my home country of South Africa, but across the African continent. So yeah, I think without further ado, let's get started. So it seems like the majority of you are in the beginning stages of protecting your IP. I'm going to focus specifically on trademarks, but before we do that, just a brief overview. Intellectual property is separated into two main sections. The first being your registered IP, and the other being unregistered IP. Registered IP consists of patents, designs, trademarks, and plant breeders' rights. Now, an easy way to distinguish between these is your patent and your design protections are designed to protect the product that you sell. Whether that product is a computer process, some pharmaceutical, a piece of technology, clothing item, etc., etc. Ideally, you'd look to get patent protection and design protection for that, but that isn't always possible because one of the key requirements for patent and design protection is novelty, which means that the thing that you're looking to protect needs to be original, not just in the territory that you're looking to protect, but around the world, which is quite an onerous condition. And so many businesses, whilst they would love to get patent and design protection, are forced to look elsewhere. Then in terms of unregistered IP rights, we've got copyright, know-how, and unregistered trademarks. Copyright can be very important and very powerful, especially from a cross-border perspective, because it doesn't require registration. And the rules governing copyright protection are very holistic, whether you are in Cape Town, South Africa, like Christoph and myself, or in Nigeria, or in the EU. There's been a harmonization of the laws pertaining to copyright, which is designed to assist, especially creatives, but copyright protection can extend beyond just creative pursuits to branding, for example, of businesses, which I think pertains to the startup space. And then, yeah, what I'm going to be discussing more today is trademark protection. So, in a nutshell, a trademark is the brand of your business. It'll be the name that you trade under, but it will also be things like your slogan, individual brands that are sold under the main umbrella brand. If you've got characters, those could be registered as trademarks as well. And the beautiful thing about trademark protection is that novelty isn't a requirement. And that doesn't mean you can pick and choose trademarks from around the world that you like and incorporate them into your own business, and nothing's going to happen to you. But you don't need to be the first person to think of a brand. There are two a convenient example here is the Discovery trademark, which is a well-known television channel, which is streamed throughout Africa, as well as the Discovery Health Company, both trading under the same trademark, but acting independently of each other, and they both have independent trademark rights. Now, the reason that's possible is because trademark protection doesn't grant you a blanket protection. Your protection is specific to the goods and services that are of interest to you. So in your startup spaces, you will likely be focusing on one or two key products or key services, especially initially. And so when you look to register trademarks and when you look to see if your trademark is available, you'll focus on those goods and services. And the way that we do that is through 45 what's known as niche classes. And these are somewhat arbitrary assortments of goods and services. And so your trademark registration will usually be in one or two classes. Now, this is all quite high level, and it's, I suppose, a good indication that when seeking trademark protection, first prize is always to speak to an attorney, especially when you're looking to expand beyond the borders of your own country. The technical element and the legal elements involved can be quite tricky, and the risks associated with doing it yourself can be quite high. Excuse me. So yes, that's kind of in a nutshell trademark protection, an overview of trademark protection. So let's go through a practical step-by-step in terms of protecting trademarks. So I see from the poll that a lot of you have started to look into trademark protection. I assume many of you have already chosen a brand, perhaps are already trading under that brand, and that's perfectly fine. There is no time requirement when it comes to trademark protection. You are welcome to begin trading before you register. You don't actually need to register if you don't want to, although it is obviously recommended. But let's say that you've already chosen the brand, and yeah, you're happy with that brand and you'd like to perhaps register that brand if possible. So my recommendation for a first step would be to conduct Google searches. Google is always your friend, whether it's looking to protect a patent or to choose a new brand. Google is always your friend. Don't just search for the brand itself, but search for the brand in relation to your goods and services, and see if you can find anything that is either identical or, importantly, confusingly similar, because that can be a problem as well. Assuming you haven't found anything, the next step would be to ideally approach an attorney and conduct what we call an availability search. That entails cross-referencing your chosen brand with the registered and applied for trademarks in the territory that the search is being conducted in. So if you're based in Kenya, for example, you would approach my firm, for example, Adams & Adams. We have a reach in Kenya as well. Alternatively, you could approach a local firm to do the same thing, and they would conduct a Google search. They'd conduct a cross-reference search of the Kenyan Trademarks Registry and see if your chosen brand has already been registered. Provided it comes back clear, you'll be given the go-ahead to file a trademark application. And once that's done, you're looking at about a 2 to 3 year period. And this is not specific to Kenya. This is fairly consistent across Africa, although we have a few territories where lengthy delays can be experienced. But if you look at a ballpark figure of between 2 and 3 years, that's how long the registration process takes. So that's great. At the end of that process, then you'd have a registration in Kenya. But now, the purpose of this this masterclass is obviously cross-border protection. And so once you've got that registration, how would you go about expanding into other territories? Well, it's pretty much the same process. Ideally, you'd conduct individual availability searches in all of the different territories of interest to you. You'd hopefully get the go-ahead, and then you'd file separate trademark applications there. As I'm sure many of you can imagine, this process can get quite expensive. So my advice would be to seek protection of your trademark in your home country, and go the whole 9 yards through with the search and the applications. But if budget is an issue, you can look to leave out the searches in some of the African countries. You can also obviously look to file applications only in the countries of greatest economic significance to you. Another idea or suggestion to get the most bang for your buck is to file what we call an ORP application. Now, the ORP agreement, or regional system, should I say, is an agreement between majority French-speaking countries in Africa, and it allows you to file one trademark application which covers, I think it's 19 different African countries, including Benin, Burkina Faso, Cameroon, Central African Republic, Chad, Congo, Equatorial Guinea, Gabon, Guinea-Bissau, Ivory Coast, Mali, Mauritania, Niger, Senegal, and Togo. And that's one application, one set of fees, and that covers you for all of those African countries. So that's a great way of expanding your reach into the rest of Africa without necessarily having to break the bank.
Sorry, Neil, just on that point, if I may interrupt you.
Yeah, of course, Christoph.
You're on a roll, but we're learning. I'm very aware that most of us are kind of early on in the stage of looking at IP and so on. So let's just take it step by step. And I wonder if there is someone in the room that wants to be our case. I see Lithium has raised his hand. You can lower your hand if you don't want to be a guinea pig for us to maybe see how Neil will advise you in going about in tackling your trademark challenge that you have. So you may raise your hand. You'll see there's a little button. Any attendee can raise the hand, and we can bring them in to actually explain to us, and then we can maybe talk them through the process with you. So anyone that wants to have the advantage of the free consultation, this is your opportunity. Just raise your hand and we can bring you in. But I wanted to ask you, Neil, so just to maybe step back. So just to confirm, so about trademark, it's important to register your trademark because that is how you'll be known in the world. And no one else. If you have the trademark, you've got the legal grounding to protect that name and the way that you're known in the world.
That's right. And that actually brings me to an interesting point, which is why do you register trademarks? So the first reason is to allow you to trade, because once you've got a registered trademark, that acts as a defense from someone else saying, you're not allowed to trade under that name. So that's obviously mission critical. To be able to trade across Africa, you need the rights to do so. So that's the first and most important reason for getting a trademark protection. The second would be to stop competitors. So once you establish some sort of a reach, aside from the financial benefits, you also get the benefit of copycats. And usually those copycats will try and ride on your existing brand. And so by registering a trademark, you have the right to prevent them from trading. You can have what's known as counterfeit raids and seize their goods in some cases, and it can be a very powerful mechanism in that sense. The third, and I think often forgotten benefit of trademark protection is licensing. So I'm sure most of the attendees here will know the company Nokia. They were a massive tech company, well, I suppose they still are, but they had a massive reach, especially sort of 10 to 15 years ago. They stopped selling phones of their own, I suppose 9 years ago, but they continued to be extremely profitable. And the reason for doing so was because they were prodigious filers of patents. And once they had filed those patents, they would sell or license them out, and then they would receive a passive income without actually producing any of the tech themselves. And that's a model that a lot of companies, especially tech companies, follow. And obviously that's in the patent specific sphere. But from a trademark perspective, especially with startups, we don't always have the capital to set up operations in multiple countries around Africa. And an easy way around that is to obtain trademark protection, set up a model that works, and then look for licensees who will take on the risk and the startup costs themselves, and you'll receive a passive income through the leasing of your brand.
That relates to patents. So let's just park patents for a moment and stick to trademarks.
No, as I said, that's trademarks and patents, Christoph.
Two. Okay, both. Yeah. Patents there is a different kettle of fish altogether. I think.
Quite right.
Is that correct?
That's right.
So if we stick to trademarks for a moment, so this is deciding on your name, the words that you use, but perhaps also the images.
Yes, of course, as well as the slogans, and it'll also be an amalgamation of the two.
Yeah, and your advice to a startup is first register this in the territory that you're operating from, and move from there. Don't go and spend all your startup money on trademarking all over the show. First start off in your own territory. That's right. Does that give me some rights that if I go into other territories and someone's maybe copying before I got there, if I've registered in one territory?
So the registration itself, no. Trademark rights are territorial, so your registration only gives you rights in the territory in which you register. Yeah. You can, however, get or obtain cross-border rights through use. So if you set up a business in one of the other African countries, and that business obtains some renown and some fame, the word of mouth and the marketing material and marketing efforts that you've done for that business will spill over into neighboring African countries and perhaps even further. And that spillover advertising fame will potentially give you some rights. Look, it's not guaranteed, and not all territories treat well-known rights the same, which is why the first prize would always be to register trademarks in territories of importance to you. But theoretically, if you do come across someone who's seen your brand and ripped it off, there are options available to you, even if you don't have registrations in that territory.
Yeah. And then your advice was identify the territories where you're likely to do the most business in.
That's right.
Maybe have a priority list, sort of, so as it is affordable for you to go into a new territory, do registration in advance, but do the ones that you're more likely to do business in. And if you're operating in the French-speaking countries, there is the ORP that you can access to do one registration for several countries. But for the rest,
exactly.
Is there talk of the free trade zone opening things like trademark up to a unified system too?
It's been part of the conversation for a long time, but unfortunately, it seems to hit several walls. And I suppose this is not specific to trademark matters. Finding a free trade agreement across Africa has been something that's been on a lot of people's hearts for, the last 5 decades. But yes, it is in theory part of the conversation, and obviously we hope in our lifetime to see something like that. There is an ARIPO agreement, which it's not quite the same as OAPI, but they are looking at sort of a one-stop shop for African trademark registrations. It's in its infancy. It's still not a path I'd recommend for clients, but it's something to definitely keep watch on, and hopefully at some point it'll be something we can look at.
Okay. So I picked up you spoke about the 45 classes. So, when you've got your material, your name and the wording and the slogans and the logos and so on sorted out, and you've done comparative searches, Google and so on, and you know it's novel, it's different from others, you still have to decide which class you are falling under.
Right. So it's unfortunately not a decision. You just need to know what your class is. So if you're selling clothing, for example, that'll be class 25. If you're selling food, it'll be from classes 29 to 31.
Maybe possible that you could fall under more than one class. So you actually
have to a lot of businesses do.
Yeah. So there is in fact then some consideration to be applied there. Which are the important classes for you to register on?
Yeah. So the key take home for that, aside from the fact that there are multiple classes and that'll unfortunately increase the price as well, especially when you start adding in territories. But what you need to look at is that not every good or service that you are involved with is something that you want to register your trademark under. So if you have T-shirts, for example, that are part of your marketing program, but you aren't actually selling the T-shirts, then clothing wouldn't be something you'd look to register your trademark for. So yeah, it's very important to identify not just the goods and services that your trademark is used in respect of, but specifically what is the function of your business. What are you selling to the public? And that'll be the class that you want to protect in.
Okay, great. So let's before we go on to our next guest, which is Kema, Joshua's raised his hand. So Joshua, you're live now. You can speak. So let's just what question you would have to Neale in terms of trademark registration. And let's start off. What is your business?
Hi everyone, my name is Joshua. I run AMC South. It's an incubator, and what we do is that we co-found businesses, we'll co-found technology businesses. So, but my question is, can you have like a particular trademark in a particular country, say like in Nigeria now, and maybe if I'm going to a new country, then I have a different trademark?
Yes, yeah, that happens a lot actually, especially with, for example, wine companies, because oftentimes the brand that you trade under in your home country is not available in other countries, and so then you are forced to choose a new brand and use the same products but sold under a different brand there. So that's something that happens a lot, and you're perfectly entitled to do that.
Great. So, by the way, there's an example. You know, you can have your quick free consultation here with an IP lawyer on this masterclass, like Joshua did. It's up to you. So you can raise your hand if you have a question. Otherwise, remember there is the Q&A button that you can click. I see there's no one that's actually logged a question there. Please put your question there if you have one. And then, of course, I see that we had Chaka and Oluwa and some others, Gioma, participating in the text chat, explaining it to us what they're about, what their businesses are, where they're based. It is really nice to see that we have a spread of people from different countries. I see Nigeria is very well represented here today in terms of, at least in terms of those that are participating in the text chat. We also have Marvin from Zambia, Komi from Togo. Who else from Benin is Kogurato. I hope I pronounce your name right. And Chaka from Zambia. So welcome everyone. It's great that we can have these kind of platforms nowadays without getting into aeroplane or driving over the continent to be connected with each other and learning from each other. So thank you very much, Neale, for that introduction. We'll come back to you with some more discussion.
Great.
So let's, we can actually, I'll do that for you, mute you so we keep the sound quality good. We can do another poll. So we are about 30 people in the room now, learning from each other. We've got some experts to help us, to guide us. But let's launch another poll. It should come onto your screen right now. Asking you an important question there around your plans to expand into other territories. Are you planning to expand into new territories soon? Is the question. Let's see. I can see my screen quickly. Then, oops, that's not exactly what I wanted to do, but we'll get there. That's about it. So, also for the recording, we are screen sharing it so others can see, and you can see there how people are voting. So, are you planning to expand into new territories? No, I'm not planning to expand. Or yes, you are. There's some different options there, but only in about 5 years. It's not right now, or three or 4 years, or the next year or two. Or you're already involved in expanding into other territories, other countries. Let's see how the voting goes there. Different options for you. So the voting goes. Please participate, guys. I see Lethan still has his hand up, so let's promote him into the room. Maybe he's got a question. Okay, I'll give you another second. If you haven't voted, please do so quickly. We're going to stop the poll now, and then we can share the results with everyone. I'll also put it onto the screen here on this side, so it goes onto the recording. Sorry, it got stuck there now halfway. There we are. Oh, now I'm moving my stuff around. Sorry, guys. There you are. So yes, in the next year or two, so about close to half of people on the masterclass are saying that they are planning to expand into new territories in the next year or two. Some a bit further away. Most of us are planning to do that in going into the future. I think perhaps we wouldn't be running startups that are geared for expansion if we weren't planning to go into new territories. So, and then we can stop sharing that for now. So that's a good introduction for you, Kema. Let's unmute you. Then we can have a discussion with you too. You're dealing with businesses that are in that space of wanting to expand quite often, different countries, and have some experience with that. So what is your approach to that, and the advice that you give startups when they go into that space of planning for expansion into different countries?
Yeah, thank you, Christoph. So that's pretty much what we deal with quite often. Businesses that are represented very much in this room. So we had a case where I think it was 0% that said they're not currently planning on expanding. 33% said they are going to start planning in a year or two, and then the bulk said in the next 5 years. So we have this kind of distribution. We see it quite often. But most of the people we advise in our law firm, most of the startups we advise in our firm are often startups who receive funding. And the thing with funding is that it changes the ball game. Once an investor comes into your team, you pretty much cease to be a local business and you start to think the way the investor thinks. And when an investor comes with a few millions of dollars and the investor shows you that your market is too small, you would begin to think of a wider pool of options. And that's when you begin to think of your sub-region, you begin to think of your continent, you begin to think of how to scale your business model. So most times when startups are at the bootstrapping stage, it's business as usual. But when an investor comes on board, they begin to see a wider picture. And when that wider picture comes on board, they then begin to have these questions in mind. Questions like, how do we operate in other countries? Do we need to register in other countries? Do we need to register patents? Do we need to register trademarks? What are the legal compliance issues? You know, the questions now become a bit complex at that stage. But then, of course, with the right advice, you know, it gets easier. So with this in mind, the question, I mean, I'm trying to narrow it down to the conversation on trademarks here and intellectual property protection. With this in mind, when a startup knows that funding often changes the entire equation, and with funding comes the necessity of expanding into new markets. You know it's an inevitable evil. It's something that must happen if you have any intention of profitability on a big scale. You know, of course, there's some businesses that just want to stay small, which is okay. The family businesses, community businesses, and that's fine. But if an investor comes on board and thinks your model is something that can be scaled and you know, driven to other countries, then that conversation you're putting off to the next 5 years is something you should start to have now. And the reason is that if you put it off to the next 5 years, what would happen is that you might have gained notoriety in your home country. Your business model would have been so successful, and thanks to the internet, thanks to social media, you probably would have done a lot of PR and advertising and publicity on the internet. And what will happen is that your brand would gain notoriety a lot faster than your legal protection rights. And that poses lots of challenges for you, because someone could easily take your business model, take your brand name, and run the same identical service in another country. And in the next 5 years, when you would want to penetrate into that country, it becomes almost impossible for you. So it's we often advise startups to be a bit proactive. If you would eventually approach investors, it's best to start thinking like the investors. An investor wants to think of markets. In any case, even if you're not thinking of investors at this stage, the AFCFTA is about to happen. The AFCFTA is real. African countries have ratified it. We're just on the first phase of implementation, and we'll get to the next phase and the next phase. The international community is behind it. So it's going to be a reality in our lifetime. And the earlier we plan for these things, the better for us. And it will pose a huge challenge for you to have an entire continent at your doorstep, but you can't effectively trade in another country, practically because you've not secured your rights in that country. Again, it's an internet age, it's a social media age, and you would most likely advertise your businesses to the extent that people in other countries would hear of your brand before your brand comes to those countries. And it poses a huge challenge for you. You just create more battles for yourself years down the line. We have cases where people do these things on the internet. People, I don't know what they're called. There's a technical name for them. They pretty much buy domain names that could be popular. So they buy those names and keep it. And the same thing happens with trademarks. The same thing happens with patents. So we had a case in Nigeria where someone registered the trademark of idols. Idol, the way we have Idol West Africa, and the other one. Someone registered one in Nigeria and sat down and waited patiently for them to come to Nigeria. So someone registered. They've taking those steps to register popular brands in other countries, and they folded their hands and waited for those brands to come to the country. Of course, when those brands came to the country, it posed a challenge. Of course, there are some ways around it. One of which is licensing. So in such a case, the brand simply gives out the license to a local player in that country to pretty much trade with that name. But then it still opens the door for legal issues, and there are lots of legal scuffles, because the case in hand is still undergoing litigation. Because what happened was that they gave a license to a firm in Nigeria to trade with the name without having to register that trademark in Nigeria. So you might have that case where you have an amazing brand. You've done so much social media campaigns, and your brand becomes popular around Africa, but you are only playing in Nigeria. And then time comes for you to go to South Africa, for example, and someone smart in South Africa who has seen your name and who has seen that you're probably going to come to his country in the next 5 years, he goes ahead and registers a trademark in his country. And in the next 5 years, when you're ready to go to South Africa, you'd have to, you'd have to face, whatever music you see. So it's really about being proactive at this stage, and that's what we advise the startups that we advise. That's what we advise the startups in our domain. Be a bit proactive. Think like an investor. Think like you already have investor funds, and just start to secure protection in as many countries as possible. At least key territories where you are most likely going to trade in. So countries like South Africa, countries like, if you're in West Africa, come on, you must register in Nigeria, Ghana, if you know, South Africa, Kenya, Uganda, Ethiopia, Egypt. You know, there's some key countries where you should have that presence. And like Neil said earlier, that there's an agreement with Francophone countries where you have access to about 18, 19 countries, you know. And if you're thinking expansion, you should think of the Francophone countries as well. And the cost, I mean, if you think of the cost in the long run, it's quite negligible. It's quite, it's not something that will break the bank. Most people just haven't even found out what it costs. In Nigeria, I think the dollar equivalent would be about, definitely not up to $100 to register a trademark. Not up to $100. I think in South Africa, it's about the same range. Yeah, you could correct me if I'm wrong. But, you know, if you register in these two countries, for example, you've protected yourself from a whole lot of headache you would encounter in the next 5 years. You save yourself from litigation. You save yourself from reputational issues. You save yourself from a whole lot in the next 5 years when you eventually plan on expanding.
Kema, you mentioned quite an interesting point there in terms of the role of potential investors. So I'm wondering if perhaps there are any of the startups in the room today that are at that phase in their development where they are looking at setting up relationships, or where there's some funds flowing into them from a VC or something in that regard. It doesn't need to be a VC even, just a new partner that's investing and that may have different expectations. And managing that in terms of the meeting of the expectations around protecting, you know, managing risk, I suppose, is the right way of seeing it. You know, so if you have more parties involved, in managing of risk may become a more important issue for everyone to agree around. And of course, managing the IP and the protection of the IP is a major risk for a startup. So if there is anyone in the room that is at that space where they have other parties that are getting involved in the business, whether it's investors or otherwise a partner, and the managing of that process, the decision making of that process that are causing you some challenges, then you can raise your hand and we'll have a discussion around that. Or if there are any other questions that you have that you want to raise, you can also raise your question by clicking the Q&A button. I see no one's raised questions, so it looks like Neil and Kema are doing a great job in explaining it. But if you have specific questions around your situation, you can put it into the Q&A. But Kema, if I can come back to you, you know, sort of, so I see immediately there's Joshua putting a question. So please take Joshua's lead as an example, other people in the room, and put your questions there too. We'll come to your question, Joshua, just now. Or if you want to speak about it, you can raise your hand and we'll bring you into the room like we did with Joshua also earlier.
Joshua asked an interesting question. I'll read it out. I don't know. Does everyone have access to the questions here?
Like everyone can see it, yeah, but you can read it, that we know what you're talking about.
Okay. So he's asking, was it possible someone registered Google trademark in Nigeria before Google came to Nigeria, looking at Google invented it? You know, so yes, that's an interesting one. It gets asked quite often. What if someone registered Coca-Cola in another country before Coca-Cola came to that country to register? But there's in law, there's something what we call equitable rights, you know, and you earn those equitable rights. I'm sure Neil passively mentioned it in passing when he said, if your brand has gained such notoriety that a home country will not register that name because of that the notoriety of that brand. So it would be obvious, it would throw a red flag to the home country that something unethical or a fraud is in the process of being committed. You know, in such a case, the home country will not register that brand. And obviously Google falls under one of such. You know, if, for example, a country like a newly created country. I think the newest country was South Sudan. So let's imagine a day after South Sudan was created, they create a trademark registry, and then someone quickly rushes to register the name Google. I can bet you that the name would be denied because Google has already established that notoriety. But you and I might not have that privilege of establishing brands that have that level of worldwide notoriety. And as such, we would not be accorded those kind of privileges. We would just not be that privileged. So yes, I think Google is the example of Google is it's quite on the extreme, because of course you wouldn't be able to even with some names like Obama. I doubt, I don't know. I mean, I wouldn't know if Obama has registered the name in every country, but good luck trying to register Obama Foundation in your country. It would most likely be declined because the question will be raised as to the link between your foundation and the Obama we know. And once there's no link, then there would be the likelihood of deceit, fraud, and questions of that kind. And as such, it would most likely be declined.
Yeah, great. So let's stick with you for now, Kema. We can come to Neale. I see Neale's been answering some of the questions too, so we can ask him to maybe repeat some of that. And by the way, Natalie, if you're prepared to bring your question live, you don't have to. So, but if you can switch on your camera if you want to speak live, because you're now in the panelist room, we can get your question live. Otherwise, you can type it. We will take it typed too. But let's look at Femi's question to you, Kema. So Femi is saying, if your brand name differs from another with just one alphabet, one letter, but you operate in a different sector from that already established brand name. So whichever that brand name is that's registered, say, I think if you say sector means the class, do you foresee any challenges in that trademark registration? So it's just kind of one small variation, and it's not in the same class.
Yeah. What usually happens is this, a trademark doesn't happen automatically. You'd first of all do an availability search, and after the availability search, you then have to go through the process of registering. And one of the important things that the registry always looks out for is to protect brands and identities that, or rather to avoid duplication of similar brands. So if a name being brought for registration has the likelihood of confusing the general public as to the connection between both brands, yours will likely be declined. So if there's a likelihood of confusion as to the difference between both brands, then yours is likely to be declined. So for example, you might bring Goggle, G-O-G-L-E, or G-O-O-O-O-G-L-E. It would probably still be declined, particularly because they're both strikingly similar. So in the process of registration, the consideration does not merely fall on the individual letters being used. The logo also comes to play. If your logo is strikingly similar to an existing,
it looks like Kema's internet, your internet is going a bit slow there. So let's give it a breather. I wanted to ask Neale, so if you don't mind, Kema. Neale, have you had interesting declining applications that you actually were surprised by? Let's just unmute you quickly. If I can get to Neale, you don't have to worry. I'll do that for you. There you are. Now you can speak.
Yeah, you get it a lot. Not many. Well, the most interesting recent example I've got is actually in China. our client filed an application for a logo that was I think it was a giraffe, and it was declined because someone else had registered a logo of a water buffalo. And to me, that's ridiculous because they look completely different and it's different animals. But the Chinese registrar found them to be confusingly similar. And I suppose that touches on what Kema's point is. And that's really the key question that you need to ask yourself, because it's what the registrar is going to ask itself. And if you were ever sued or look to sue someone else, that's the question the court would ask. Is there confusing similarity, or is there a risk of confusing similarity? I've also had a trademark rejected, and this happens a lot. And it's not something that we've discussed really in this masterclass, but in order for a trademark to be registrable, it needs to be how the courts have described it as sufficiently distinctive to function as a badge of origin. So what that means is that the mark can't be descriptive. So if you sell hay bales, your business can't be hay bale salesman. And that kind of goes in opposition to a lot of marketing lecturers who will say that the perfect brand name explains exactly what the business does to a customer that hasn't heard of it before. So that's kind of the line you always need to walk. You need to make sure that your trademark is able to explain what your business does, but at the same time, it can't be so descriptive that it isn't functioning as a trademark and doesn't give you any rights. So I think that's an important consideration for all the attendees here to bear in mind. I think we lost Christoph.
Yeah, I think we lost Christoph. Well, there's a question here. It says, for example, you get to a country and discover that your trademark is already registered there. What action would you take? Neil, you want to go with that?
Yeah, let me jump in. So it'll obviously depend on the class that it's registered in, but let's I suppose go worst case scenario. So you sell soft drinks, your trademark's already been registered in respect of soft drinks in a country that you're looking to expand into. Now, on the face of it, you wouldn't be able to trade in that country, because by doing so, you'd be committing trademark infringement. So you'd look to see, is the company that's registered the trademark using the trademark? If it isn't, the trademark registration might be vulnerable to cancellation. There's a mechanism in most trademark territories around the world that if a trademark's not used within a certain period of time, usually 5 years, that mark can be applied for cancellation. So we'd look at potentially doing that. Obviously, if you've been trading in the territory, you might be able to apply for cancellation based on your fame in that territory, and the fact that the application was filed mala fide, without intention to use. But if those options aren't available to you, then you're going to have to approach the company that registered the trademark and see if they are willing to license the use of the mark to you. And if they're not, or if the price they're asking for is unreasonable, then the only real option is to choose a brand, a different brand that you'll trade under in that specific territory. And like I mentioned, I've got a few wine clients that have been forced to do this, through their expansion plans. And it's not a great situation, because it means that all the goodwill and fame you've generated around the world, you are not able to rely on in the specific territory. But it is the only real option if the other options I've discussed aren't available.
Yeah. Christoph still isn't back.
I see, sir.
Yeah. But anyways, it's pretty much an interesting topic. But what I see happening the most is not so much the realization that it's not important, it's really, for most startups, it's really a question of apportioning resources, scarce resources for competing needs.
Exactly.
You know, so you have lots of startups who are thinking revenue growth, sales, expansion into local markets, penetration into local markets, who think little considerations like protection of your intellectual property rights are not are important but not urgent.
Yeah.
You know, so they know they would handle it at some point, but you know, they would rather just play around it now. But okay, I see Christoph is back.
I've got a major internet crash happening here. I'm not sure if I'm showing up upside down now, or can you see me?
Yeah, you're upside down.
Yeah, upside down.
Okay, let's see. It looks like I'm going to stay. Let me stay like this. So I'm on my phone now. We had a major internet. My internet is just died for some reason, which doesn't normally happen. Normally it's quite stable. But in any case, so I'm sorry, guys, for that. So I've kind of lost track of the questions now. So you guys will have to help me there. There was a question from Kema, I think, around the issue of, and Neil, I think you started to answer that around use of one lawyer or one representative for many territories, you know, sort of. So I know there's some firms like yourselves, Adams and Adams is quite a large firm that reaches out to different territories and being able to help people in that regard.
Yeah.
While Kema, I think your firm is quite small and maybe specializing more in terms of the needs of your immediate clients. So what is the advantages of those two different, and maybe each of you can just speak to that, you know, sort of. So on one hand, you can have Adams and Adams that reaches many territories. On the other hand, you can have a Capitalfield attorneys that is more local, but able to reach or to meet the needs of the local community or the local founders better. So maybe first, Neil, if you can speak to that.
Right. So I think the benefit of having a firm like Adams and Adams is that you're able to exercise control holistically. So if you're a business and you're looking to expand into multiple territories, then being able to work through one firm means that firm, along with yourself, has an overview of, you know, the development of your brand, and that can help them and yourself to catch potential problems before they happen. So I found that to be a great benefit. We also have, you know, through our reach and the various local offices that we work through, we are able to sidestep some administrative issues as well that can be problematic. And hopefully it allows you to expedite the trademark registration process as well. But I think the biggest benefit is that overview. Having we've lost Christoph again. Oh, there he's back. Having, you know, one or two sets of eyes that are overseeing the whole project can help make sure that everything is consistent and that you don't you know, lose any potential protections through the cracks.
Yeah. Great. And from your perspective, Kema?
Yes. I would say with most of the clients we work with, like I was trying to make the point earlier while you were off, Christoph. It's never a question of the importance, but most times we get it's often a question of the urgency, and as such, things like intellectual property protection is always put off. It's kind of always stuck in the to-do list. You know, one of those items that perpetually stays on that list but never gets done. You know, so that's pretty much where that is, because people can't really frame their minds around the essence, the urgency, the importance. Well, they kind of know it's important, but that sense of urgency and you know, strict importance. So what we do with our firm, Capitalfield Attorneys, is that we work with we work with these startup founders, and we're quite selective with the startup founders we work with. We like to work with startup founders who are at that transition phase, who are at the stage of breaking beyond a local one-man business into into a deeper level of expansion. So we're quite selective of the CEOs and founders we work with in the startup space, and that's because we like to work with people who are thinking markets, who are thinking about market penetration, who are thinking of new opportunities, who are thinking of expansion, who are thinking of a global reach. And what we do with those people is that we help them guard against their risk. We help them manage those risks. And the thing with risk is that you don't know what it is. So it takes the advice of an expert. It takes the advice of someone who has advised on such transactions over and over again to tell you what to put in place, to tell you the decisions to make to avoid getting into those pitfalls. Lots of CEOs would rather make business decisions, but when you have partners like Capitalfield attorneys, we advise you on your risk, and advising on your risk simply is all about helping your defense stay strong, because it's no use having a good attack when your defense is porous. You'd score wins, you would succeed, but you would open yourself to unnecessary litigation. You would open yourself to unnecessary legal issues that could just crumble your company. And what's the point at the end of the day?
Yeah, indeed. So my apology for that interruption here. I'm not sure what happened to my internet. It's back up. So, maybe there was just someone sneezed somewhere, and for a moment I couldn't have any internet. But yeah, I'm here back. So I lost the thread of the questions. If I'm missing something now, please post it again. But I've got Joshua's question around the recording. So yeah, indeed, there are quite a few people that have registered for the masterclass that could not attend. And we are doing a recording. We'll be sharing a recording that anyone can watch later on, including yourself, Joshua. So I hope that answers your question. I'm not sure, Kema and Neil, if there are any other questions that you've noticed that you would like to address. So by the way, any attendee in the room, you're welcome to post another question or to raise your hand. If you raise your hand, we can bring you into the room and you can have a free quick consultation with two trademark and IP lawyers. Don't get that often. If you have specific questions you want to discuss with them now, we can do that too. So we can bring you in the room. Otherwise, type your question. Thanks, Joshua. So we've dealt with the video recording thing. And then Femi is asking how you can be contacted. So can we ask Neil and Kema, if you could just type into the text chat. I know, Kema, you are on your phone, so it may be a bit difficult, but just type your contact the way that you wanted to be contacted.
Yeah, I just did. Okay, on the text chat, right? Okay.
No, not in the Q&A, in the text chat. Well, I'll be able to copy yours. Don't worry, I'll copy your email. Open, that's easy for me. So there's Kema's and Neil. If you can just type yours to
sure.
Let people know how to make contact with you if they want to pursue any of these questions that we discussed here today. I've got yours down, Kema. So there's Neil's in the. So I'll put Neil's in the chat too. Anyone looking for it? It's now both of them are in the text chat.
Okay.
I'll be sending it to the panelists. Sorry, I must be sending it to everyone. So let me just make sure they're both the email addresses. Okay, so Michael has got another question. So by the way, if you have questions, please put them in now because we're going to close questions quite soon. For example, you get to a country and discover that your trademark is already registered there. What action will you take? That's Michael's. So I'm not sure.
I think Christoph, that question, we answered that question while you were down, actually.
Oh, okay. Okay, cool. The questions are now starting to come back to me. So if there aren't any more questions, shall we close the discussion with a final round of comments? Thank you very much again, Neale and Kema, for your sharing your knowledge and participation here today. Perhaps if there's a final comment you want to make, sort of, I saw a quick hand going up. So if there's a chance for us to, it disappeared again. So let's close the questions then. So let's ask for a final round of comments, sort of. So if there's something you would like to leave with us today as a final comment. So let's start with you, Neale.
Final comment. I think it's something that Kema's touched on a few times, but prioritize IP protection. The costs can seem prohibitory, and I think it's always going to be something that you push down the list in terms of priorities, but that can lead to a lot of headache and far greater expenses down the road. So I think, look, if you can't afford the protection, that's one thing, but if you can, then I would recommend prioritization. It doesn't need to be incredibly expensive. There are lower cost alternatives if one firm doesn't suit your needs. And as I mentioned earlier, you don't need to seek protection in every single African country. You can prioritize there too, but prioritize IP protection as far as possible. I think that's my closing comment.
Great, thank you very much. And from you, Kema?
Yes, Neale has said it, prioritize it. But aside from prioritizing IP protection, I feel like we did the attendees a disservice by not by focusing a lot on trademark protection, because I actually failed to talk about the fact that your developers, people who develop your apps, because most startups produce online-based services or app or software-based services, products and services. So your developers, your agreements with your developers, they need to be watertight. Not just those, even with your staff. Your employment agreements need to be very, very clear as to who owns the rights from all the inventions that come out from your employees. So none of your employees gets to work on a product and tomorrow they say it's theirs. So it needs to be very, very clear from your employment contracts and from your engagement contract with your developers. It needs to be expressly clear that all intellectual property rights belong to you, and under no occasion do they transfer to the developer or to your staff or to third parties and all of those. So yeah, and someone was asking if our rates are SME friendly. Oh yes, we have, aside from the law firm Capitalfield attorneys, we have an on-demand legal service. It's called Àjèbó Lawyer. We launched recently. We launched about 3 months ago, and we already have about 1,000 users. What that service, and I'm sure lots of the entrepreneurs here would find that quite interesting. What the service does is you simply send an email. You just send an email to client@àjèbólawyer.com, and whatever legal documentation need you have will be handled for you in the next 24 hours. So you don't need to get a law firm. You don't need to pay exorbitant rates, and the pricing is incredibly SME friendly. In Naira is about 4,999 Naira to get the document drafted for you in less than 48 hours. So it's something we just deployed into 3 months ago, and we already have 1,000 users because of the convenience, the speed, and the efficiency with it. So you should try it out, especially with your agreements you have with your developers and employees.
Great. So can you type us that address in the text chat, please?
Oh, okay.
Sorry, Christoph. Before you move on, I see there was a question we missed in the text chat from Natalie Texera. She asks, my company is registered as a closed corporation with sub-businesses. E-commerce is first business venture. Is this registered correctly as a trademark? And I think that's a confusion that a lot of people have. So when you register a company, that doesn't actually give you any trademark rights. It just sets up the company as a separate legal entity. But you aren't able to stop others from trading under your trade name. And if someone else has a registered trademark, that isn't a defense for you. So on top of registering your business as a closed corporation, you also need to look at trademark protection in your home country. And then obviously if you're trading elsewhere in those other countries as well.
Yeah, I tried very hard to convince Natalie that she must switch on her camera, but she wouldn't. So thanks for picking up on that deal. I think, Kema, you raised something that maybe may direct us towards the next topic of a masterclass, and sort of the element of protecting the IP developed in a business, not only from a trademark and a patent perspective, but from the relationships with other people inside of it, and specifically the technical people that are doing development, and that can easily take some of the IP being developed there and go apply it somewhere else. So that's a very important pointer that you reminded us of there, and perhaps we can look into that for a future topic too. So, by the way, if there are any topics, you can let us know. I'll put HWeb's email address there too, if you need to contact us. So there's a whole lot of contact details now there in the Zoom, the text chat. So attendees that would like to connect with anyone, you can please feel free to do so. Just click on any of those links, and it will take you to that appropriate person. By the way, if we end the webinar, that will disappear too, so you better copy it down now so that you don't lose it. I'll keep the webinar going. I'll keep the room open for another minute or so while we wind down. But let me again thank Neale, and let me actually go to the gallery view and we can see everyone. Let's thank Neale and Kema for your participation here today. And of course, this is a collaboration between the Àjèbó Foundation and the Tony Lemele Foundation. And we invite participants are from both our networks, so in the pipeline of the Àjèbó Fund and in the alumni and participants in Tony Lemele Foundation activities are people that are coming to these events. And let us know, sort of there you've got the email address info@ajweb.org. You can send us if you have any topics that you would want us to cover in the future. It will be from next year onwards again. So great. Thank you everyone for joining us. I see Emmanuel, Gildas, Gloria, Ramana. Sorry if I'm slow in pronouncing your name. Joshua, who participated. I think Joshua was a star participant today.
Agreed.
If there was a cup to hand out, he would have won it. Jude, Kwame, Majid, Marvin, Michael, Isabello, and so on, Victoria. Thank you guys for joining us today, and keep looking at your inbox. We'll invite you to the next one too. Have a great day. I'll keep the room open so you can copy those email addresses for a moment. But otherwise, let's say goodbye.
Cheers, everybody. Cheers, Kema.